Good morning from Berlin. My name is Reinhard Bütikofer. I'm your host for the webinar that you are joining, and we will spend the next hour and a half or so discussing the state of play and the expectations around the comprehensive agreement on investment that the EU has been negotiating with China for the last 7 years. And of course, all of you are aware that already last year, both sides agreed that it should be brought to a conclusion, if possible, by the end of this year. Now, you also have certainly heard several times from European Union officials that we have taken the attitude that substance goes over speed, and we want to have an agreement that is indeed worth having. To discuss where we stand and where we need to go and how things evolve, and we have invited three experts for this morning, one of which had to drop out. It's something that always can happen. Professor Wouters is sick and he cannot join us, and we wish him the very best. But that leaves us still with two excellent experts whom I'm going to introduce to you just shortly. First of all, we have Alicia Garcia Herrero. She is the chief economist for Asia Pacific at Natixis. She also serves as senior fellow at European think tank Bruegel and non-resident research fellow at Madrid-based political think tank Real Instituto El Canto. She is currently adjunct professor at the Hong Kong University of Science and Technology and member of the advisory board of Berlin-based China think tank MERIX. Finally, Alicia is advisor to the Hong Kong Monetary Authority's research arm and the Asian Development Bank, as well as a member of the board of the Hong Kong Forum and co-founder of Bright Hong Kong. Thank you, Alicia, for joining us. Then we have Tim Demayer. Tim Demayer is senior advisor on standards policy with the International Labor Standards Department of the International Labor Office, headquartered in Geneva. He currently oversees the Centenary Standards Initiative. From 2014 to 2018, he served as director of the country office for China and Mongolia. He managed decent work country programs for China and Mongolia, promoting more and better jobs for men and women, social protection, social dialogue with employers and workers, and respect for fundamental principles and rights at work. We're grateful to both of you for joining us from Hong Kong and from Geneva, and excited to hear what you have to tell us. And I would say, without much further ado, we should jump right into it. And I would invite both of you to give us roughly 15 minutes of your take, where we are, where we could go, where we should be going, where we should avoid going, whatever. Please take the floor, Alicia first, and then Mr. Demayer.
Well, first of all, it's really a pleasure. Can you hear me?
Yes.
Good. It's really a pleasure to be part of this seminar. It can't be more timely because we are indeed at the very end of a long process which started in 2013, and you know, we all want to know not only whether the deal is going to be agreed upon by the end of the year, but what kind of deal, and very favorable it might be for Europe. So my role here is really to go through what I would personally consider to be a favorable deal. And I don't think I can.
Just a second, Alicia. The
Yes.
sound is not extremely good. It varies. So if you speak more directly into the microphone,
Yeah.
that helps a lot.
Yes, I'm trying
This
to
is
find
good. This is good sound.
Yeah, okay. So I'm going to talk about what I think should be a good deal for you. And I can't really, let me see if I can you hear me or should I put it louder?
Louder.
If I knew how to put it out. Let me put it very loud. What about now?
Can you use a headset maybe?
Yes, but I need to ask for one. If you can't hear me well, I would propose, if you don't mind, to have Team first, and then I will ask for a headset.
Okay. Okay.
Yeah. Yes.
We just shift.
Yes.
If you're fine with that, Mr. Demayer,
Yes.
we start
Sorry
with you. We change the order. Is that okay for you?
That is perfectly fine, if you can hear me well at least.
We hear you perfect.
Okay, excellent. Thank you very much. And well, thank you for the European Parliament, the organizers, for inviting the ILO to this seminar, and a very good morning, afternoon, evening for all those listening in. I think we have a rather impressive set of participants. I'm going to talk a little bit about how we see the situation with respect to international labor standards as they are accepted by China. And we do that from the viewpoint that the ILO as an organization supports an open global economy because it basically thinks that the benefits in terms of job creation and standards of living is outweighs the undeniable drawbacks that there are from uncontrolled globalization. So we see very much international labor standards, ratification of international labor standards, and respect for fundamental principles as key elements in making sure that that the forces of globalization get to benefit everyone. So my first few observations are on ratifications of fundamental conventions. Many of the participants may be aware that in the ILO we have 8 fundamental conventions dealing with, 2 each dealing with 4 fundamental principles, and these 4 fundamental principles are freedom of association and collective bargaining, elimination of forced labor, abolition of child labor, and elimination of discrimination. So first, a little bit, where are we with the, where is China with respect to the ratification of fundamental conventions? Well, at this point, 4 of the 8 fundamental conventions have been ratified. That means 2 with respect to the elimination of child labor and 2 with respect to the elimination of discrimination. And that therefore means that the 2 standards, the 2 sets of conventions, one with freedom of association and collective bargaining, the other one with forced labor, are still to be ratified. First, a few observations on Convention 87 and Convention 98, freedom of association and collective bargaining, in many ways considers the most fundamental of the fundamental conventions by the ILO. As far as we understand there, China has no intention of ratifying these conventions anytime soon. There is actually a lot of information available with respect to the position on freedom of association and collective bargaining. That can be found in the country baselines that we have on the ILO website. And for those of you who are interested, I'll be quite willing to point you to that, because they're not necessarily easy to find on our website, even though they are discussed once a year in our executive council, the governing body. Without going into the details, the principles, the principal position that you can derive from there is that, and I quote here literally from the first ever report that was submitted by the government of China, is that the principle of freedom of association, the effective recognition of the right to collective bargaining, is recognized in China. And you do have laws and regulations that contain explicit provisions. Also reference to the Constitution, where rights, fundamental rights that are associated with freedom of association are also recognized. Freedom of speech, press, assembly, association, procession, and of demonstration. So if you unpack that a little bit, it would not be far from the truth to understand that the saying that China attaches great importance to these fundamental principles, but very much understands it within the context of its own political and legal system. Obviously, the way in which it is understood at this point in time is not the way that the ILO supervisory bodies, the ILO as an organization, understands the standards in these two conventions. And the issues, of course, that most frequently, the difficulties that with respect to Convention 87. Can you still hear me? Because I get a message that it's okay. Okay. So the issues that most frequently are cited as posing difficulties with freedom of association have to do with the required independence of trade unions from the government and from the ruling political party. There is a law imposed trade union monopoly. The structure of trade unions in China is rather top-down instead of bottom-up. There are difficulties with the ability of unions to join international federations, and of course rely then on the support of these international federations. And although this is of course something that is altogether more controversial, the right to strike in China has been dropped in 1982 from the Constitution. Most often cited as a reason is the aftermath of the Cultural Revolution. But at this point in time, the right to strike is not explicitly recognized also in legislation. We do have currently a complaint pending before a governing body committee on freedom of association with respect to arrest and detention of advisors and paralegals. I am not going to go into the details there, but the case can be found also on the ILO website. It is still an active case, and it brings up, amongst other things, this question of the independence, the ability of workers to organize independently from any political party in particular, and also from employers. That is what I would initially say with respect to freedom of association and collective bargaining. The other fundamental principle in the area of which the fundamental standards have not yet been ratified is the elimination of forced labor. So there we have three instruments. We have a convention of 1930 that basically requires countries to eradicate forced labor from their territory and to penalize perpetrators with criminal sanctions. That has been complemented by a protocol in 2014 that looks at, shall we say, the more modern forms of slavery and the push and pull factors that are responsible for forced labor being rather persistent throughout the world even today. And then we have another convention from 1957, Convention number 105, that deals perhaps more with as is sometimes said, the state-sponsored forms of forced labor. rather than the economic motivations to have to rely on forced labor. So also there, we have details in the country baseline. The information that we have at this point in time is that the Chinese government is reactivating its examination of the prospects of that convention number 29 in particular, also the protocol, not convention 105, and I'll come back to that in a second. As far as convention 29 and protocol 29 are concerned, convention 29 first, we have been working very closely with the Chinese government and the social partners to have Convention 29 ratified, in fact, since 2003. It has been, there have been gaps in the cooperation, in the sense that between 2007 and 2013, there was basically a slowdown of the active examination. And that had a lot to do with the key obstacle that the Chinese government had identified with respect to ratification, that is the system of re-education through labor, which is essentially which we would call, and also the human rights community would qualify as a system of arbitrary detention that was introduced in the 1950s and was aimed predominantly at the re-education of people with a different political opinion, and a political opinion different from the mainstream opinion. So that system was formally abolished in 2013, and since then we've continued our cooperation. In addition, 2019, the so-called custody and education system for sex workers was eradicated. A similarly arbitrary detention system for sex workers, and that is considered, should be considered another step towards facilitating the ratification of that convention. As far as Convention 105 is concerned, Convention 105 is a fairly short convention where a lot is left unspoken, but where on the other hand, I think the messages are also fairly clear. No forced labor as a punishment for violations of civil and political liberties. So that includes freedom of expression, that includes freedom of association, freedom of assembly. No forced labor as a punishment for strikes, and no forced labor as a form of racial, social, national, or religious discrimination. That convention is considered very closely associated with, of course, with the civil political rights that are laid down in an international covenant of the United Nations of 1966, and that China at this point has not yet ratified. So the prospects for having that convention ratified probably also go a little bit, end up a little bit on the back burner. So in sum, if I sum that up in terms of what can reasonably expected in terms of ratifications, and we hope, of course, that the situation evolves positively, in the sense that the International Labour Conference has also repeatedly called for the universal ratification of all fundamental conventions, most recently in its centenary declaration last year. So the International Conference is fairly clear on it. But I think honesty requires us to say at this point in time that the chances of ratification of Convention 87, 98, and 105 are relatively minor. In terms of ratifications more generally, a couple of observations. China has ratified 26 conventions in total, which is not very high in the sense that if you compare it, for example, with the global average of around 42, 43, so that is well below still. Also, amongst the BRICS, the Brazil, Russia, India, China, South Africa. China has the lowest number of total ratifications. But what is perhaps more interesting is if we unpack that a little bit, there has only been one ratification since 2007, that the Maritime Labour Convention, specifically focusing on the protection of seafarers. There's no ratification of the labor inspection instruments at this point in time, although we've been on and off working on that together since 2008. And the labor inspection instruments are, of course, have much to do with maintaining a level playing field in the context of international investment flows. There's actually amongst what we call the technical conventions, there's only 8 conventions that are truly up to date. So if you leave the fundamental aside, there's only, and the governance conventions, of which there are 4. So out of the remaining 14, there's only 8 technical conventions that are truly up to date. And amongst these are 3 occupational safety and health conventions, very positive, even though there are some difficulties with respect to the application, but that is, of course, not an extraordinary situation, given that working on preventing accidents, injuries, and diseases requires a bit of infrastructure, a bit of system building that requires a certain amount of time. So there are 3 of the occupational safety and health conventions ratified, and we understand that 2 or 3 more safety and health conventions are also being examined, which again is positive. We also understand, and we are working together towards the ratification of Convention number 102, which sets minimum standards for social security. China has made very significant progress with respect to making social protection universally accessible, particularly in the areas of healthcare and old age pensions. And it would really be, in our view, a very significant reassurance of China's commitment to multilateralism if that convention, which we are promoting with the support of the European Union, by the way, would come through. I'm not going to say too much, but just a little bit. Ratification is not everything. At the end of the day, ratified standards need to be applied. And if we look at the application of the fundamental standards that are ratified by China, there is still a fair amount of work to be done. There's Convention number 100 and Convention number 111. Convention number 100 deals with equal pay for men and women for work of equal value. And there we find, for example, that the principle has not yet found expression in the laws of China at this point in time. And that is something that our supervisory bodies have been repeating for a number of on a number of occasions. Positive development recently, and something that's been evolving since 2005, also with the ILO support. Positive development recently is stronger provisions on protection against sexual harassment in the new civil code. On the other hand, we do see that there is still a what we would call a discriminatory retirement age between men and women at this point in time. China is not alone there. A lot of other transition economies making the transition from a centrally planned economy have that sort of provisions on their books. There is the rather big issue of rural migrant workers, which China is actively working on, but which is very difficult to tackle. The full recognition, access to social security, education for children, and so on for workers that migrate from the rural areas to work in urban areas. There are still discriminatory provisions for people living with HIV/AIDS that we hope to see some progress on, as well as in respect of pregnancy and maternity, of course, with the lifting of the one-child policy. Protection of pregnancy and maternity is something that goes hand in hand, and we hope also there to see some improvement going forward. With respect to the child labor conventions, I think just to pick out two of the issues, it's a bit of a concern that we are not able to get any data, labor inspection data in particular, on violations found with respect to child labor. This is something that makes it difficult for us for the supervisory bodies to see if the standards are properly applied. And another issue is also been discussed for a good number of years, the hazardous work for interns. So some of the apprenticeship systems that do not function entirely the way we think a proper school to work transition program should work. Maybe now that the organization is set to adopt new standards on apprenticeships, this is an area where we can see further progress. Very quickly noting that Hong Kong, the special administrative region in Macau, and I'm not entirely sure whether they're included here in the negotiations on the investment treaty, but they do have different ratification records that in principle at least should stay in place until 2047 and 2049 respectively. In conclusion, I do think that it is not unreasonable for the European Union to insist on ratifications, for the simple reason that EU member states have all ratified these standards themselves. I also think it will be important for the European Union as a capital importing nation to include a clause according to which investor protection claims based on violations of responsible business conduct by investing companies should not be upheld by courts or arbitral tribunals. That is, if one reviews a little bit the experience with the China-Canada investment treaty, that is an area where many observers feel that there has been a hiatus in the treaty. I think I will leave it at that. I think I have already gone slightly over my time. I apologize for that, and I'll be happy to take any further questions, realizing that here and there I haven't fully elaborated on some of them, perhaps more complex point. Thank you. You're muted. Mr. Bütikofer, you're muted.
Yeah, thank you very much. I thought that was extremely interesting, and I'm sure there are going to be quite a few questions coming your way later. But now we return to Alicia Garcia Herrero, and you were about to start telling us, Alicia, what should be a good investment deal with China. Please take it from there.
Thank you so much. You can hear me well now?
Perfect.
Oh, I'm so happy. Okay, so I'm going to develop basically 4 main ideas as to how to judge whether this comprehensive agreement on investment can actually improve on where we are now. So the first of all is to judge where we are, how unprotected we are with the current 25 BITs, bilateral investment agreements we have, everybody about Ireland. The second thing I'm going to do is to focus on what we gain compared to the status quo. And third, any concessions that we may need to do. Of course, I don't know whether we will, but I'm going to explore which could be the most likely, whether within the agreement or in a parallel form. And I'm going to basically argue that if this is the case, this of course, the price of this would of course be very high. And finally, I'm going to look into how much progress the EU has made in the past agreements we have signed, for example, with Vietnam or others, and whether that progress is expected to be there in this deal with China. So in other words, are we following up on what seems to be a new trend in terms of, and by the way, the World Comprehensive Agreement on Investment should indicate that that's where we're heading, but are we really heading there? So with all of that in mind, let me start with the status quo. So I will be brief on this. There is a very interesting briefing by the European Parliament itself, really going into detail. So I don't think it's necessary for me to do that. But perhaps I want to highlight the fact that the existing agreements, let alone the fact that they are different, and of course this in itself is an issue, but most importantly, they only cover investment protection. So they don't deal with liberalization measures or market access. Now, we need to also realize that China's liberalization measures, and I think the most important for this comprehensive agreement on investment is surely the foreign investment law that just passed in 1st January this year, are actually multilateral liberalization measures, meaning that they would be there for us whether we sign a comprehensive agreement on investment or not. Of course, this doesn't mean that we can get any better, but I'm just saying that China is liberalizing. I'll go in detail as to what this foreign investment law really means, but that in a way doesn't require a comprehensive agreement on investment. Of course, on market access, and that's going to be the key point of whether we're getting something out of this, that's a different story. That could be bilateral, as we do have in the phase 1 deal with the US for some specific issues, in particular, financial institutions, access to China. And the question is, are we getting anything of that, of a similar tone as the US? And bearing in mind that what the US really got on the phase 1 deal is very little market access. I mean, what is in that deal is mainly, as you all know, a big purchase of imports of 200 billion that I don't think we'll have anywhere in the comprehensive agreement on investment, because that's not the goal of obviously a treaty. So it's very different, and I don't think we should compare the phase 1 deal, which is temporary and not a treaty. So on that note, I would end up by saying on this status quo that, of course, it's fragmented, it's not ideal, but it's not a cliff. because it does provide investment protection of different nature, country by country, but it does provide that. So on the second point, the long-standing request, of course, by the European Union for this agreement was really to have better market access, and by doing that, improve reciprocity, because we'd offer better market access to China by obtaining more. I mean, that in a way would immediately imply improve reciprocity. Now, what do we really mean by market access? So, of course, relaxing non-tariff barriers, and very importantly, allowing foreign companies to enjoy the same levels of transparency and fair competition as non-foreign companies operating in China. Does the foreign investment law achieve this goal? Well, it improves, obviously, on the previous situation, because it replaces existing laws on wholly foreign-owned enterprises, sign of foreign contractual joint ventures, sign of foreign equity joint ventures. It puts all of that together into one single law, and it protects, or at least it includes in the law, the protection of, or the avoidance of forced technological transfer and a number of other improvements. But I want to insist on a very important point, that this is a law only for foreign companies. In other words, China still today, and this is very different from Europe, has a different legal treatment of state-owned enterprises, private enterprises, and foreign enterprises. And that has nothing to do with the way we operate in Europe, where we have the very same commercial law for everybody, the same competition law, etc. So my sense basically is that it is indeed an improvement, and I repeat, the foreign investment law is there, I mean, no matter what we do with this treaty, but it doesn't really ensure that level playing field that we are at least aiming at with this agreement. So perhaps I'm sure that you know, if somebody would say, but does this foreign investment law open up the doors in terms of market access, yeah, beyond the reciprocity and the level playing field? What about market access? Well, this foreign investment law basically is the way for China to move from a positive list to a negative list, which is obviously welcome. And this negative list has been shrinking up to the latest form on June 24 this year. But it still has 33 sectors, some of which, frankly speaking, not necessarily, in my humble opinion, very close to national security or even key strategic sectors. Well, it all depends on, you know, your definition of strategic, but I can mention a few: telecommunications, automotive, education, of course, media, etc. So it's a wide range of sectors that are in the negative list, meaning that they're not subject to this foreign investment law. Perhaps one more thing to add on the reciprocity, level playing field, and market access is surely the fact that yes, the foreign investment law is an improvement, but other things have been changing in China lately in the opposite direction. And this is not only true for foreign companies, it's true overall, but that doesn't make it less worrisome, especially the national intelligence law or the cybersecurity law. So the question really is how to deal with these laws. What if they come in contradiction with our own legal framework in Europe? Perhaps I should end by mentioning that there's also the rollout of a corporate social credit system, which again might complicate surely the business climate of European companies operating in China, and that again might come in contradiction with some of our own GDPR or other regulations. So that's the second point. Now I'm going to move to what we could, because whenever you ask the question, it's always like we're not giving up anything. It's all like a gain, and the question is how big the gain. uh, in this second part of my presentation, I was trying to say that the gain is not massive because that the foreign investment law is there anyway. And as far as I know, and it would be great to have some negotiators at this event to hear more, I can't really see major achievements on market access or level playing field beyond what the multilateral arrangement of a law that is there for every foreign company would offer you. But beyond that, the question is there anything in exchange? And there, I think, in conversations, informal conversations, and even, the statement that the Chinese negotiators have made public, there's always this idea that they don't want the European market to be closer than it has always been to Chinese investment. Of course, the question is from where? Where do we put the bar? Because our investment screening mechanism has only entered in force this November. So are we talking about a situation before that? And therefore, that investment screening mechanism would already be a constraint or considered to be a new constraint to what might be agreed. And beyond that, of course, we still have our white paper on foreign subsidies that could also potentially be subject or change that. The situation of that would be agreed in principle, given China's main request, which is that no conditions are changed in the European market. I know that we also want to include our right to regulate, which is one of the key themes of this new way to reach deals in Europe. But the question is, who has the upper hand in these two ideas? I want the market access this very same way it was before, as opposed to the European view of I want to have the right to regulate. In other words, it's hard for me to measure what could be at stake from our side, but it seems to me that something could come, because the whole idea is nothing can't change in terms of market access and equal footing, obviously. Finally, as regards the type of agreements we've been signing lately, and Vietnam again is an example, but there are many others. I think it's important to remember that we try very hard to include new goals. It could be obviously climate change goals. It could be, of course, role of SOEs. It could be, quite a number of important topics for Europe. That I want, well, of course, we heard from ILO, and I think Vietnam is a very good example. So the question it really is, are we going to tone down those requests for this specific agreement, or are we going to go full win in requesting China what we have been asking elsewhere for our put it this way, newer investment or trade agreements? So that's the key question for me. How high is our bar? And I guess only when I have answers to all of those questions, how high is our bar, how many more concessions we may have received in terms of market access, I could then answer the question, does it pay off? Because, and this brings me to the very last point of my intervention, there is a cost. There is a cost, at least I would say, in rushing into a deal, for a number of reasons. The European Union's situation today in terms of bandwidth to really deal with this major, in my opinion, agreement, because it's politically very important. It's not obvious. We are in the midst of a pandemic. Our economic situation is certainly not that of China in terms of first in, first out. I just wonder why, there's this perception that this is the time, really the one and only time to sign this agreement. And on top of that, and it you know, I realized that we would love to be economically, I mean, sovereign in the sense that we take our own decisions, but frankly speaking, we are only a few weeks away from having a new president in the US. And I just wonder whether this is really the best timing, whether we can't really wait a little bit longer. And we don't even need to put it this way, because there's so many things I mentioned before that seem to me, as of today, not yet clear, from the ILO conventions to targets which were not announced yet on other than 2060, but I don't think that can be considered a workable target, yeah, in terms of you know, emissions, or maybe perhaps we could think of actual targets within the next 5-year plan that China could already hint at for our agreement. So all of that, I think, requires time. And while there's obviously an interest from the European side to reach an agreement, the only point I'm trying to make is that the way I see things is that our advantages don't seem to be crystal clear. They may be crystal clear in a while, but they aren't crystal clear now. And I would end on this note. Thank you very much. There's no right. Yeah,
Sorry. Thank you very much. That gives us a very good idea of the different dimensions from which you can and have to look at a possible deal. And now I would like to invite participants to join the conversation and to post questions or make remarks. And I will then read those to our two panelists and ask them to respond. And I will immediately start with the first two remarks that I find. You can go to the chat, or you can go to the Q&A section and post your remarks. One is from Chiara Miglioli. She says, we can fairly assume the EU could try to get access to those sectors that are excluded from foreign investment law. You mentioned telcos and cars. What would be the real added value from access in those sectors? That's one question. And the other is a remark by a participant in the chat. This is Jan van Herf, and I read it to you. Before digging into the expectations of asks, please clarify what the EU can deliver. So far, the EU has not successfully ratified any full-fledged BIT since it assumed certain competence in this area under the 2009 Lisbon Treaty. Since the ECJ ruling on the Singapore FTA in 2017, it is clear that at least certain elements are of mixed competence and hence need ratification in all relevant bodies in EU member states. Is it realistic to expect from our negotiating partners to enter into any ambitious and comprehensive agreement with the EU in this area, which point to mixed competence, minding, e.g., the CETA saga or the halloumi cheese in Cyprus as a late example? So these are the first two remarks, and I would like to add a question from my own side to Mr. Demayer. The forced labor that has been reported upon as being sort of applied to members of the Uyghur minority, for instance, in the ASPI report from February this year, I understand that this would be in the field of the Convention 105. So if we would seek a protection against practices like that, that would force us to insist on um, um, China ratifying Convention 105, right? Or would that be covered by Convention 29? That's the question. And I would start with Alicia, and then move over to you, Mr. Demayer, and we will, while you answer, we wait for more questions and remarks. Alicia, please go ahead.
Yes, thank you, Mr. Butikofer. So I guess the questions really, I mean, I think this comment is more something like, can we actually do anything since we don't like ratifying treaties? Well, I mean, that goes beyond my expertise. I'm a humble economist, so I don't think I can add more. But the question here is not whether it will be ratified, it's whether it will be agreed. And my comments are really on whether we should agree on such a deal. And there again, the key issue is what you gain, what you lose. And I'd like to have a much clearer idea, if I may, from the negotiators on this front, because I just, no matter how much I search for it, I just can't find it. And I think, frankly speaking, it should be easier. I understand they are still negotiating, but it would be nice to have a better view, frankly speaking. On that regard, there is a question as to whether this comprehensive agreement on investment will be achieved by the end of the year. I'm nobody to judge. Maybe it will, but in my opinion, given what we just heard in this seminar, I don't think we are ready by the end of the year, unless there is a path-breaking situation. And I'm also trying to, and this brings me to the next question: is China motivated to make concessions to the EU at this point in time? Well, I mean, I guess China really wants to get done with this deal, especially before, frankly speaking, Biden comes to power, in my opinion. We had that with our CEP, so it's not a new thing. But the question is Europe in the best negotiating position now, given what's happening? Is this so urgent? The next question I would ask. I mean, why before the end of the year? Can somebody explain me why this is so urgent? I just don't understand why this is so urgent. By the way, China's outward FDI into the world has collapsed in 2020. I don't think it will come back, frankly speaking, but the point is there is no immediate urgency unless the gain to be made in terms of market access, again, reciprocity, huge change in the legal framework. This deserves it, but why rush into it without that? For me, and it's not only about Europe. It's also about China, because I think this is a great opportunity for China to introduce a number of concepts. One is, of course, competitive neutrality. I didn't mention it in the presentation, but I think this would be great. In a way, US-China missed that boat because they wanted to rush a deal in December 2019 because it was good for Trump for the elections. I guess it was good for everybody, yeah. But in a way, they missed the chance of working on a concept, which is a workable concept, to measure the degree of distortions in China's market because of the role of SOEs. And I don't think that's good only for Europe. Actually, I think that's even better for China because it would make China even more competitive. So that's the point I'm trying to make, that I don't think rushing into a deal is of any interest for any of the two parts unless they think strategically, or but more than strategically, actually, on the fact that politically speaking, this is the time, more fun for some than others. I think more than for China than for the EU. But that's the only reason I can think of to just rush it. And my take here is not so much about whether we should sign it, but the fact that we shouldn't rush it. Yeah.
Thank you. Mr. Demayer, please. You are muted.
Yes, thank you. Thank you, Mr. Butikofer. To the short answer to your question, whether the treatment of the Uyghurs, as we understand it, based on the allegations that you're referring to, the question as to whether that is a Convention 105 issue exclusively, the short answer is no, probably, unfortunately. It depends on, because it is of course a very complex situation, and it would depend on what aspect of the allegations you are focusing on. And unfortunately, I cannot go here into too much details, because some of these allegations will in future be examined by the ILO supervisory bodies. But in terms of questions, just to illustrate a little bit what I was saying, just in terms of questions under Convention 29, one of the questions would, for example, be whether persons, Uyghurs or other persons who have been detained without due process, whether they are in the context of their detention, whether they are being asked to produce goods that will then find their way into private commercial circuits. That would be a relevant question under Convention 29. Another relevant question could be, to what extent are people in Western China, in Xinjiang, to what extent are they under any sort of coercion in order to help the cotton harvest come in? That would be another relevant question. Under Convention 111, you would look at whether the extent to which any coercion is exerted, to what extent does that weigh disproportionately on certain ethnic minorities compared to not just the majority, but other ethnic minorities. So there is the question of discriminatory treatment overall. And under Convention number 122, the Employment Policy Convention, which China has ratified, the question would be whether, for example, Uyghurs that, as it is mentioned, that graduate from vocational training, to what extent do they really have free choice in finding, accepting employment either in Xinjiang or in other parts of China? So that means it would raise questions with exactly how the labor transfer program functions. So I've highlighted here at least 4 conventions that all, in the context of which, all of which questions could be raised, and some will be examined, given that China has ratified, out of the 4 I mentioned, they have so far, therefore, not yet ratified 29 and not yet 105. But they have ratified Convention number 111 on non-discrimination, and they have ratified Convention number 29 on forced labor. Not 29, 122 on employment policy.
Mm-hmm. Thank you.
You're welcome.
There's a next round of questions and remarks. One is from a Chinese participant, Chen Yangsheng. who asks, do you think that the BIT could be concluded by the end of this year? And I would, to sharpen that question, would maybe add, so under what conditions do you think it could be concluded? So what should be the improvements vis-a-vis the status quo that, as far as we know, in order to facilitate a conclusion before the end of the year? Then Gudrun Wacker from Berlin asked the question, does China have any motivation at this point to make any concessions to the EU? You've already approached that a little bit. Alicia, maybe you can come back to that. And then there is a question from Jörg Haas, also from Berlin. China is a country, he writes, with a very specific economic model where the distinction between private sector and public sector is blurred, not only due to the prevalence of SOEs, but also because the CCP is omnipresent throughout the economy and in all companies, including private ones. What specific risks to the EU with respect to its defensive interests could result from that? And then there is another question from Chiara again. Is it possible to assess, based on the available information, whether China could use the tools of CAI to challenge FDI screening or the forthcoming legislation on foreign subsidies? And I would like to add a question from my side. You mentioned the concept of competitive neutrality. Maybe you should try to explain to our participants what would be needed to implement such a principle. For instance, with regard to the role of SOEs in the Chinese economy. I hear that that the Chinese side has promised, since they joined WTO, that SOEs would act in the marketplace according to market logic. And this is again being touted as an achievement in the negotiations. So what, in addition to such a promise, would we need for competitive neutrality? This is where we are at the moment. Most of the questions go to Alicia, but I will invite Mr. Demayer later to join the conversation if he wants. Alicia, please.
Thank you. I will start with your question, if I may, Mr. Butikova, because in a way it answers part of the question by Mr. Haas on the role of SOE. So the idea of how to protect European or any other foreign interest in China, and in particular protect our interests as regards the what I would say the working of corporations in China is not only us, to some extent is also the case of private companies. Not every private company, because as Mr. Haas is pointing out, some private companies actually may have originated from central SASAC companies once upon a time, and they've been into different types of ownership, and thus, in a way, originally they were central SASAC, and maybe the structure of the company hasn't fully changed, if you see what I mean. So it's very complex. But what this concept of competitive neutrality tries to achieve, and I think that's why it's a very good starting point, and it was first developed by Australia, and other European countries have worked on it, and there's a lot of standards developed by the OECD as to how to implement it. So basically we're on a good framework that has already been tried out. And I think first it requires um, legal neutrality. And this brings me back to the idea that we need a company law in China, which covers everybody, not separate different types of laws depending on your ownership. So first thing I would argue, and that's a big thing that I don't think we're going to get there by December, if you think about it. So you need a company law. And second, beyond the legal neutrality, you also need financial neutrality and fiscal neutrality. So in a short blog that I hope will be published soon by Bruegel, we try to measure at the sectoral level the degree of competitive neutrality between Chinese state-owned companies and private companies. We don't even measure for foreign companies, first of all, because there aren't enough. And we find that both for financial and tax neutrality, SOEs tend to benefit, either because for every unit of debt they pay fewer interest. So it's not about the amount of leverage, it's really that they have cheaper access to funding. And second, their effective tax ratio is lower. And it's really across the board, except for one sector, and the sector is very interesting, is the real estate sector, many of which used to be SOEs. You can think of Evergrande and many other private developers today that have state origin or local government origin of some sort. So I think, again, in the spirit of China's quest for reform, I think a competitive neutrality concept that is worked both on the legal, tax, and financial side could be welcomed by every side. I mean, by both sides, because it would also protect the interests of private companies in China, and I think that's something that maybe we could work on. I know for a fact, because there was a lot of push by the IMF during the negotiations on the run-up to the phase one deal, that there was a lot of difficulties to really, the PBOC, I think, was more in line with developing this concept, but it kind of came to a dead end. So perhaps I then very quickly add to, what is at risk for our companies. Well, think about the state secrecy law, for example, a very important piece of legislation, which of course somehow affects everybody, but especially SOEs. So think about getting into a joint venture or getting into, well, we know this, of course, for IPOs in the US recently, and the US just reacted, I believe, Thursday or Friday with a new piece of legislation. It's very hard to work on an equal footing if even the financial statements or other types of supposedly public information cannot be unveiled. So I think that's frankly very, very important. I don't think that the letter of the law matters a lot in China, and we need to kind of smooth this differentiation by which one of the players, i.e. a European company, is obliged to inform, and this is the new laws that I mentioned on all types of information, where you store your information in the cloud and blah, blah, as opposed to the exact opposite, the state secrecy law, by which you don't really know even the most basic financial statements. So I do think this can hamper competition, frankly speaking. On the last question, I really don't know, because I guess nobody will put this in written anywhere. But the question is, what if there is room for interpretation as to what we mean by offering China the exact same access that they already enjoy with this new treaty. You may say that's no change of conditions, but in my opinion, it is, because it obliges you never to change such conditions, no matter the circumstances. So I don't think you will ever see in written that this means, that the FDI screening device or our new legislation is at stake. But the question is how to interpret that exact same market access in the future. That would be all from my side.
Thank you. Do you want to come in, Mr. Demayer?
Only very briefly, Mr. Bütikofer, because I don't really feel qualified to talk about some of the questions that have just been tabled. But one thing that one observation that I would have is not to underestimate how different a system China is, and also not how different its current level of development is. And then I speak about China as a whole, and necessarily the Eastern Seaboard cities that we are usually most accustomed to. One question that in the context of neutrality, because it will be very difficult given the enormous challenges that China has to ahead of it, it will be very difficult to expect that system to change. That's my personal view. But on the other hand, in the context of neutrality, which of course is a concept I think is very good, as I said earlier, I made the recommendation. I said, look, I think it is perfectly reasonable for the EU, just like it has done in the FTA with Vietnam. It is very reasonable to say we expect, just to take the ILO's area, it's very reasonable to expect a investment trading counterpart to ratify all the fundamental conventions. It is, after all, something that that the ILO has repeatedly called for. Because you have to realize, of course, also that applying these conventions is not easy. It requires, for example, a certain industrial relations system. It requires a certain level of consultation. It requires a certain respect for the right to strike. It requires a certain infrastructure in terms of consultation at the level of the undertakings. All of these things take time and take money. All of the EU member states have submitted themselves to those regimes, are regularly reporting to the ILO, and are doing everything they can to apply. And so it is perfectly reasonable, in my view, for them to also expect trading partners, even if in the beginning that will be difficult, but to gradually make every effort to work their way towards that. And I think at this point in time, expecting that sort of neutrality from China will be very difficult. And even if it makes its way, I think, into a treaty, you have to ask yourself the real question: how are you going to enforce it afterwards? Given that we have very little experience in terms of trade and sustainable development chapters, whatever you wish to call it, labor clauses. We have very little experience in these with these clauses being effectively enforced around the world. Thank you.
Thank you very much. We have, I would say, a last round of questions and answers. One question comes from Philippe Deponte. He asks, how do the requirements by China to have a CCP party cell in each company, domestic or foreign, factor in a possible comprehensive agreement on investment? And the other remark goes more to the labor side again, and it expands on what you just said, Mr. Demayer. I read it from Kiara. Recently, with Vietnam in the framework of the FTA ratification, the EU has obtained a roadmap for the ratification of Conventions 105, 98, and 87. Would this kind of achievement be possible with China too? If not on those conventions, what about a roadmap on Convention 29? And if I may add a little spice to that, why should we grant one communist regime a trade agreement that falls short of the criteria that we negotiated with another communist regime. And the last question that I would like to add goes to enforcement. Enforcement with regard to labor standards, to sustainability standards, but also to all the other provisions that might be included in such an agreement. So I recall that in the bilateral relations between the US and China, enforcement was a sticking point, and the phase one deal did not deliver as much as the US side originally expected, leaving aside the buying orders, particularly on the enforcement side. So what kind of ideas do you have to not just say we want enforcement, but to create mechanisms to facilitate enforcement on the different dimensions of such a possible deal? I think that's it, and I will start this time with you, Mr. Demayer, to give your responding remarks and your last remarks, because we're concluding with this round of answers.
Thank you. I'm not entirely sure I can satisfactorily answer the question, given that we are still at a very early stage with Vietnam. It's correct to say that that roadmap has been agreed. That roadmap has basically been accepted directly by the Communist Party in Vietnam. And the first results we have already seen. So Vietnam ratified Convention 98 on collective bargaining last year. It adopted a revised labor code that for the first time creates an opportunity for representative workers' organizations independently from the VGCL, the Vietnam General Confederation of Labor. So for independent workers' representative organizations to bargain collectively at enterprise level. That labor code will go into effect on the 1st of January, so that means in less than a month from now. And earlier this year, Vietnam also ratified Convention number 105. It had already ratified Convention number 29 earlier. The ratification of Convention 87, which would then conclude the 8 fundamental conventions, are foreseen for 2023. And at that point in time, or by that point in time, the expectation is that it would revise the trade union law. But that is really all we can say at this point in time. So if you wish, the easy work is done. Given that having the ratifications registered in and by itself is not terribly complicated. Revising the labor law, as long as it's on paper, is not tremendously complicated. But now the proof of the cake will be in the eating. Will we see independent workers' representative organizations emerge? Will they be able to engage in collective bargaining? Will they be able to lawfully, shall we say, bring their collective weight to bear in these negotiations? All of that we need to see. Will it be possible to reform the trade union law, given that in Vietnam's history, the trade unions have played a very significant role in the independence? Yeah, all of that remains to be seen. Now, how does that relate to China? So you're asking the questions, why grant one socialist state advantages that we don't give to another one? I think that's a very fair question. The only reason why you would do it is in deference to the, shall we say, the reform challenges that all in all are far more significant for China, because it is so much bigger. It covers so much more territory. It covers so much more different levels of development, and it does mean that some of the things that you will like to see over time inevitably are going to take more time, no matter how strong the will to reform is. Now, is the will to reform there? In certain aspects, yes, but as the other question also indicates, there are certain elements of reform, like, for example, the strengthening of the party cells at company level. Yeah, this is distinctly, I think, what is fair to say, I think, is this is not a model. The direct interference of a political party in a commercial undertaking is not exactly what we understand under a representative labor relations model. This is direct political interference, obviously, and this inevitably does raise questions as to what the will to reform is in the direction that we want to see it. I think I cannot offer much more at this point in time. Thank you.
Well, thank you very much. And Alicia, you have 5 minutes to also answer the remaining questions and make any final remark you would like to make, please.
Thank you very much, Mr. Bütikofer. Well, I learned a lot, I have to say, from ILO conventions. I'm quite impressed at the depth of issues that in a way relate. Yeah, for example, the question by Philippe on the role of the party, yeah, in a way is somehow a mirror of what we just heard. I mean, the Chinese Communist Party obviously is increasing calls on companies to support the creation of party organizations among their employees, but this is actually in Chapter 5 of the CCP Constitution. It's not new. It just so happens that the way these party units or party organizations are created is slightly different, or the function of these party units is different for SOEs than for private companies. And by the way, I want to clarify that what they call foreign invested companies, i.e. joint ventures, would be classified as private companies. So in a way, foreigners operating in China without control would indeed be in this category of private companies. And there, yes, as long as there are 3 employees that are party members, these units can be created. But their role is, on paper at least, and I guess, frankly speaking, I imagine even in beyond paper, less intrusive, if I may say that, for SOEs to start, because SOEs have to be, the CEO has to basically represent the party. So, you know, I guess it's very hard to think of anything more than that. But for private companies, the idea is that they oversee organizations, whether it's the Communist Youth League, etc. So it's not as intrusive as one would imagine just by looking at SOEs. That doesn't mean that there are no issues, because if you think about how this might affect decisions, or maybe the privacy of the decisions, I mean, that's something I cannot judge. But I can imagine that this has also potential consequences. On the question of basically the commitment and how we can actually come to terms as to whether the potential agreement will be respected, I think there's two aspects. One, of course, the phase one deal is the idea is that you meet twice a year and whatever, and then you check whether the commitments have been fulfilled. But this is what I hear informally from negotiators, European negotiators. But I just have to warn the audience that we're in a different situation than the phase one deal, to start, because this is a treaty. The phase one deal can end tomorrow. And of course, behind the phase one deal, there are tariffs to be lifted or kept. So I don't think that just, I don't know, a check every 6 months will be necessarily binding enough to achieve that goal. It might be, again, this is up to the negotiators to know, that we actually have clauses by which, if this is not maintained, etc., there will be consequences. But again, this is a treaty, so I don't know how easy it is to do that. On a related topic, the one thing to remember is that beyond market access, beyond level playing field, we also need to realize that we need an investor-state dispute settlement in our treaty. And we've replaced, the old ISDS with new two-instance investment court systems, or even multilateral investment court systems. Frankly speaking, I'd like to know whether from negotiators, if any in the audience, China is ready to accept this, because this would be quite something. Yeah. So in other words, it's not only about the deal being or our treaty being fulfilled, or the steps in the treaty, but also what the treaty is about, that investors in China or Chinese investors in Europe can actually use easily dispute settlement systems that are more favorable. So this is also one issue that I forgot to mention before, that is very important to really nail down before we sign this agreement. I think I would leave it there, because I'm right on time, I think.
Thank you very much, both to Alicia Garcia Herrero and also to Tim Demayer. We've learned a lot from you, and we realize when we listen to your expertise that there are still quite a few issues to be sorted out to really know what such a deal would be about. And with regard, for instance, to the investor-state disputes, as far as I know, China is dead set against accepting ICS system like we negotiated with Canada under CETA. So that's also not concluded yet. For me, this all looks very much as if there were still quite a few issues pending. And it would take a major thrust forward to really conclude before the end of the year, without hastening and without taking some of the issues too lightly, maybe. So I would draw encouragement from what you have explained to us for the sustaining of the approach that we have chosen in the European Union so far, saying that we want to emphasize substance over speed, and we need to clarify substance. And you have helped us understand what some of the urgencies are in that context. So for that, I want to thank you very much. I also want to thank our attendants, the public that joined this conversation, and I wish everybody a very good day. Thanks to all of you.
Thank you. Thank you for the invitation.
It was my pleasure. Thank you
for
also,
the
Mr.
invitation.
Demayer.
Pleasure talking to you.
Pleasure here. Thank you.
All safe, all good health to everyone.
Indeed, indeed.
Thank you. Bye-bye.
Bye-bye.